Now, what people don't realize sort of about the school desegregation equal protection jurisprudence is that the beginning of the end was only about 3 years later. Because again, mirroring the way that the society dealt with race issues. 1974, a decision went from Detroit up to the Supreme Court, where a judge in Detroit had ordered cross-district transportation and movement of students, because Detroit, like many northern cities, had, a concentrated black area in the city surrounded by white suburbs. And the court ordered desegregation of the metropolitan area. And the court said, no, we're not going to go that far. Number one, there was never de jure segregation in Detroit. This is just patterns of where people live. And unless you can show sort of legal segregation like you have in the South, the courts have no authority to do anything like that. So it was sort of a mirror of this classic northern-southern split. The northern part of the country saw race as a distinctly southern issue that the South had to deal with. And the North was not going to deal with it in the same way. There were a series of other decisions in the 1970s that had kind of a really profound long-term effect. The second was, I think, to the 73 or 74, the same year, as Milliken, the Detroit case, I think, the case out of San Antonio, Texas, where there was a challenge to what you hear now in Charlotte, to the lack of resources, that the poor schools were really underfunded and students were getting a second-class education. And the court ruled that there was no constitutional right to education in the U.S. Constitution. 14th Amendment, due process or equal protection right to education. That had a profound effect on what the courts would do going forward. The third case was in 1977, I think in a Chicago suburb called Arlington Heights, where there was a zoning decision that effectively kept poor and minority people from moving into this community. And the court ruled that that was not a violation of equal protection unless you could prove that those zoning rules were intentionally discriminatory. And that notion sort of mirrored this kind of national idea that we're not racist. Some of them, I know black people, some of my best friends, that kind of thing sort of went permeated all the way to the court level, that we're not going to tell people, we're not going to look at the effect of decisions you make. We're only going to look at what your declared motive is. And that too had a profound effect. So in that same time, in the 70s, there were a couple challenges to the busing plan and the Swan order, but as people know, this community settled in. And there were a couple of legal challenges in 74 and 80 to it. But Judge McMillan overruled them and said, we're going to stay under court order. And then in the 1990, you got a decision, or 91 rather, you got a decision out of Oklahoma City where there had been another finger plant, like in Charlotte. And the court ruled, and in that case, there's sort of been this thing where the court stepped away from the case, closed the case in the late 70s. And then there were all these horrible effects from sort of the kinds of things you see in Charlotte right now, and the black community moved to reopen the case. That there had never been a declaration that this dual school system had become unitary. This was the notion out of Green that you want a unitary school system. And that led to the Supreme Court to rule that, look, they've done everything they can. They've acted sort of with good faith. They've done desegregated to the extent practicable. This word practicable became kind of the buzzword for desegregation. The next year, out of DeKalb County, Georgia, which also had been, in both Oklahoma City and DeKalb, had been de jure segregation systems, they've been Jim Crow systems in their day. The courts relieved DeKalb County of supervision because the court said, well, looking at the Green factors, well, there's a handful of them they've met, but there's a handful that they haven't. And the appeals court in that circuit said, well, you keep control of that school system until they have completed all sort of the Green factors, completely become unitary. And the Supreme Court said, no. The goal here is to return the schools to the local control. That has always been the goal. And as long as there's constitutional behavior at the local level, the courts need to back off. So you could back off incrementally. And it was in that atmosphere that around that time, that CMS hired John Murphy to be the superintendent here. Bill Records here, to be honest, you were chair at some of that kind of thing, weren't you? And William, I'm sorry, I do that. And John Murphy came in with this idea of a voluntary desegregation plan, where we moved to magnet schools to try to sort of get some of this transportation and relieve it from mandatory stuff that a lot of people were chafing at, and to make it more voluntary. And as a lot of you probably know, a gentleman named Capaccione sued in the late 90s, challenged that it was unconstitutional to use race in assigning students to the schools. And that's sort of where you got in that period, you had this complete sort of flip of what equal protection meant. And now the concern was whether the civil rights of white families were being violated because they were being told where they could go to school to try to accomplish desegregation. The Capaccione case was, I think, the decision, the trial was in 1999, lasted about 6 weeks. The presiding judge was Robert Potter, who a lot of you in this room have been or around that time know. Potter had been a leader of an anti-Swan movement, I guess you would call it, in his day. The Sunday before the trial was a picture in the Observer of him standing before the school board in 1972, demanding that they appeal and ignore the Supreme Court decision. He was the judge. And unsurprisingly, ruled that they went through the green factor analysis and ruled that CMS was free of the vestiges of its segregated system to the extent practicable. But then also found that they had violated the constitutional rights of the interveners in the case, Mr. Capaccione and the others who had joined, in order that the school district pay them attorney's fees because they had come to vindicate their constitutional rights. We appealed that case. Lucy had her card from the oral arguments, and a panel reversed 2-1 and said that the school district was not yet unitary, that there needed to be more things done. And then that went up to what they call the en banc court, which is all of the judges in the Fourth Circuit, then 11, heard it, and they decided 6-5. It was a very close decision to relieve CMS from court supervision. But decided also that the white family's constitutional rights had not been violated because the school system was under a court order to use race. So they couldn't be violating people's rights if they had to choose between following the court order or sort of this concern about the constitutional rights of these families. So that was the end here for court supervision of the school district. And you can see where we are today. Amy Hawn Nelson is here. She's going to have some incredible slides. But essentially, we're almost at the same place now where we were in 1970 in terms of the way the schools work. So from that perspective, it's very discouraging. So what happened sort of the most recent step? In 2007, Seattle and Louisville went before the Supreme Court on challenges to voluntary efforts to integrate their school system. You know, there have been a lot of flips in all this. And one is that the courts had to try to force school boards to do the right thing, and now school boards were in courts being sued because they were trying to promote integration because they saw the educational value of diverse schools, which was the original foundation of Brown. So these two cases went up. Seattle had a system where you picked the high school you wanted to go to. And then if some schools were more popular than others, you then got sort of weeded out. And one of the factors considered was the race of the applicant. In Louisville, they tried to keep all their schools within 15 to 50% minority to sort of reflect the kind of range of the population of Louisville, of Jefferson County. Both of those were struck down by the court in this kind of, and this is where I said about the ambivalence. Justice Kennedy is kind of a swing vote in many, many cases in this country in the last 15 years. And in those cases it was the same, but he was dead in the middle. 4 of the justices wanted to rule that there was no interest in diversity. That the concerns that school districts had about racial isolation of students were no longer a concern of the courts if it didn't involve remedying intentional segregation. The other 4 said that they thought there was a compelling state interest in diversity and in avoiding racial isolation, and that these plans were tailored reasonably to fit within that. And Kennedy was right in the middle. He agreed that there was an interest in diversity and in avoiding racial isolation with the liberals, but he disagreed, and he agreed with the conservatives that these plans didn't pass constitutional muster. And so where we are now is very, very difficult to understand. Interesting, and you've probably heard this, Wake County, kind of in the same period from the 70s through now, attempted to move away from race-based planning and relied on socioeconomic status, and therefore avoided some of the legal challenges that CMS faced. But I think, as you've heard in the last couple of weeks, especially with, I hear the superintendent was here last week or the week before, the numbers are pretty daunting right now in terms of the level of poverty in the school district, and finding a way to kind of deal with that is a very, very difficult question. But the ambivalence of the courts about racial issues in this country reflects where we are as a society. And I'm not sure, and it doesn't bode well for sort of being able to use the courts as a way to try to address the problems that you've all been learning about in the last couple of weeks. But James Ferguson is here to be the positive antidote to my pessimism and to tell you how everything's okay.